Howdy, folks. See, more people are filtering in slowly but surely. I'd like to announce our next speaker, a good friend of mine, John Benson, Esquire. He's a lawyer. Yeah. Oh, Esquire? Yeah, it's a fantastic magazine. Yeah. And John's going to talk about when lawyers attack. He's going to be talking about electronic discovery and some of the perils that go along with it. Having had to been through this myself previously, it can be a nightmare. So, there you go.
Thank you. Well, good morning. Like Noid said, my name is John Benson, and what's that? Esquire. And today we're going to talk a little bit about electronic discovery. I know that you're probably going to have some questions as we go through. I do ask because I've got a ton of material to cover in the next 50 minutes. Just kind of hang on to those questions until the very end, and then we can address them then. What we're going to do is we're going to go through the history of electronic discovery, what it is, why this is only now really coming to light, and why this is only now really an issue. We're going to talk about why the process costs so much to law firms, to individuals, to corporations. I'm going to talk about some very simple things that can be done on a policy level to control some of those costs, even if you don't anticipate litigation right now. And then I'm going to talk a little bit about some of the vendors and some of the technologies that support electronic discovery and why that's some pretty scary stuff. But first, I want to tell you a little bit about myself if you don't know me. I went to the University of Missouri in Columbia, where I learned to hate KU, and I got a degree in finance. After that, I went to the UMKC School of Law and then took the bar exam. I passed the bar exam and was looking for a job, and I really wanted to find something where I could use both my technology skills and my skills as an attorney. And most firms just didn't really understand why that was necessary. So, I sat around looking for a job and did some freelance web design, which, of course, means I was just unemployed for a long time. After that, after running out of money, I went to work for a very large defense firm in Kansas City doing electronic discovery analysis work, which is a nice way of saying that I was a document reviewer, which translates roughly in this age to reading other people's email 8 hours a day. I did that for around 10 months. While that may seem like a dream while you're trying to get into somebody's email, trust me, it's not worth it. It's dreadfully boring and terrible. Now I work for a firm called Stinson Morrison Hecker, based in Kansas City, and I am an electronic discovery consultant. I work early in the stages of litigation and prior to litigation to help companies prepare for that. So now that you know that I am an attorney and that I am employed, you can imagine what's coming next. Nothing of what I'm about to present is anything directly from my employer or any other organization that I've been affiliated with. Certainly, none of this is meant to be legal advice to any of you all, or your organizations in this context at least. And while I am an attorney, I am not your attorney. And, of course, since I am an attorney, I am not to be trusted or relied upon in any kind of way. So, on with the show. What is electronic discovery, and where did this really large sea change come from? Well, in the law, the civil litigation process is governed in the federal courts by the federal rules of civil procedure. And up until 2006, there was nothing explicit within the rules to address electronic evidence whatsoever. Everything was conducted the same way it always has been. Finally, people started realizing that there's interesting stuff there, and we need to deal with the exchange of information between opposing sides in litigation, and they made a number of sweeping changes to the rules of civil procedure which address this. I want to address a misconception, though, that this does not affect criminal law. And depending on the situation, this may not actually affect state law cases. So if you are being sued in federal court in the civil system, you will be subject to this. If you are being criminally prosecuted, these rules do not apply. But there's a little bit of a caveat about that. A lot of federal law out there involving technology will have a criminal component as well as a civil component. That's definitely the case with the Computer Fraud and Abuse Act and as well as the DMCA. So you can be prosecuted and then you can be sued on top of that. If that's not clear, we all remember O.J. He was criminally prosecuted, acquitted, and then sued in civil court based upon some of his alleged actions. So up until December 2006, there were no provisions that required attorneys to address electronic data at all. Why is that? A lot of the times that you hear lawyers speak, there are lots of questions, and you hear, we don't know yet, we don't know how the courts are going to address it, which can be very frustrating. So the reason that you get that answer a lot is because the common law system is designed to move very slowly and very incrementally. And that common law system is pretty well reflected with the attorneys that are out there. They're very old-timey. They like to cling to their ways, and they're very resistant to change. And that's fine. But it can definitely create a lot of ambiguity in the law whenever you have new technologies coming up and new things like this. Attorneys are not exactly what you'd call the most technologically savvy individuals. If you've ever worked with a law firm or worked with your own attorney and tried to correspond over email, I know lots of attorneys that don't read their own email. They have their secretaries print them and then bring them in. And then they actually still dictate on tape, and then their secretaries will go back and then type emails and send them out on behalf of their bosses. I know some attorneys that are just now running into spreadsheets and wondering how to navigate around spreadsheets, which can also be kind of shocking in this day and age. So where do the federal rules themselves come from, these rules of civil procedure? Well, they come from the U.S. Supreme Court. And this is not exactly a spry group of individuals that is ready to embrace new things and new technology. Before Chief Justice Rehnquist retired, the average age of the Supreme Court was 71 years old. So whenever you see new cases coming up and you have real hope for some sweeping changes that make a lot of sense to those of us kind of in the trenches of technology, realize who's going to be making these decisions. I had a professor actually once refer to it as think of getting in trouble and talking to your family about getting in trouble. You go talk to your grandmother. Your grandmother's usually pretty cool. Your aunt and uncle, they're probably pretty cool. But there's always that one grumpy old bastard grandfather that just hates kids and wants everybody to get off their lawn. Think about that as far as an analog to the Supreme Court in a lot of cases. But technology in general is really new to attorneys. It's just now that they're realizing that there are interesting things in computers, and we might want to take a look at them when we're going through lawsuits. It's very frightening because this lack of understanding of technology is what's really shaping the conversations involving electronic discovery and all of the exchange of data early in litigation before they bring in experts and before a lot of people involved in technology at organizations become fully involved. Electronic discovery is, the descriptions are largely driven by buzzwords that people hear in CLEs and by urban legends. Attorneys are frightened of metadata. I remember going through law school, and we were talking about the coming changes and how technology is changing things. And I was thinking along the lines of the amazing things that you can do with forensics and going back and seeing what people have done, even though they think that it's all been wiped. And some of my professors say, well, no, it's all about the metadata. It's all about the metadata. I'm like, what the hell is what? So, I start looking, and there's not really a lot of stuff describing metadata, but all it is data about data. But attorneys think that it is something very frightening, something to be feared. And, this is a screenshot of a weblog post by this attorney, who I'm sure is a very nice gentleman and a pillar of the legal community. But he's expressing his shock in this blog post that there's hidden information in digital photos. Gasp! I mean, it's everywhere, and I'll come into a conversation some of the times, and the questions are not where is the data, how is it preserved, how are we going to get to it? It's what are we going to do about the metadata? And a lot of the times I say, well, do you really understand what metadata is? And the general consensus within a lot of attorneys is that it's track changes in Microsoft Word, and the reason which is true to a certain extent, but the fear of Microsoft Word and track changes comes from this urban legend that has spread all around about an attorney that he's typing up a bench brief for this judge, and he doesn't really like the judge. So whenever he writes the judge's name the first time around, he calls him some very foul name. And then before sending it in to the court, he changes everything back and sends it in. And this judge, of course, this mythical judge, was savvy enough to open up track changes and see all the things that were written about him, and he wasn't pleased. But that kind of urban legend has spread, and now this is where the focus of a lot of thought is with attorneys when they come into new cases. Before I move on, I want to clear up a little some confusion about what these rules are and what they aren't. These rules are not per se a compliance requirement like Sarbanes-Oxley. Companies don't necessarily have to do anything new as a result of these rule changes, and most companies haven't. What they do is they change what attorneys do and the way the process works. So unless you're in the legal process, then you don't necessarily need to do anything different than you did before. And that's leading to a lot of increased costs for companies as they approach litigation at this point. That said, companies really should be making changes to their structure and to their policies as a result of all of this. I think potentially that the rules of electronic discovery could have a more sweeping level of change than the Sarbanes-Oxley requirements that came into effect a few years ago. I mean, how many people in here had to make changes or do anything different as a result of Sarbanes-Oxley? Okay, it's quite a few. But most people haven't had to make any changes unless you're in litigation at this point in response to the electronic discovery rules. The ironic thing, of course, is that companies spent millions and millions and millions of dollars getting ready for Sarbanes-Oxley, and since Sarbanes came into effect, there have been only 2 instances of fines or sanctions against a company for noncompliance. And they came into effect in, 2004, 2005, something like that. Since December of 2006, we've already had over 60 cases of sanctions against attorneys and companies as a result of failure to comply with the new rules of electronic discovery. And the changes have mostly just kind of flown under the radar. And I think that because of the amount of money and the amount of effort that had to be expended because of Sarbanes-Oxley, the companies are now kind of saying, we had to spend all that money, now we got this other thing going on. I don't have to do it, do I? Okay, we'll just kind of deal with it as we go along. So Let's move along, and we'll now talk about how the electronic discovery process works. This is a chart from the electronic discovery reference model, which is a kind of an industry think tank. And there's a lot of great information within this chart, but it's kind of confusing. So I've got it simplified over here. Let's say that your company gets sued. We're going to work this all the way through litigation in a very simplified state. The first step, of course, is to say, what information do you have and where is it? Seems like a very simple question, but of course we all know that it's definitely not for any organization of virtually any size. Now, I can't find things on my own computer. I can only, it gets even worse with very large companies. So you have to identify what you have. Then you have to take a look at what you're being sued about, and you need to preserve that data, which this means stopping and recycling of backup tapes, a lot of times coming in and taking images of hard drives. It all kind of depends on what the attorneys negotiate at the very beginning. After that, all of the data that's going to be potentially responsive to the lawsuit is collected, and you can collect in a number of different ways. It all depends on the case. Sometimes you'll be having forensic work done. On the other side of the scale, you can have just individuals dragging over files that relate to a certain matter into a folder and putting them on a CD and sending it to their attorney. That's very, very common. After that, all of those emails and all of that data needs to be reviewed for a number of different things. Somebody needs to see if it's actually responsive to the lawsuit. A lot of times you'll need to look at the documents to see if they're privileged or not. Depending on the case, they may have negotiated that certain trade secrets will be redacted, so that information will need to be redacted. It's very, very time-consuming, as I'll show as we go on. After the initial review is done, you narrow this down to a production set that then you give to opposing counsel, and opposing counsel then will sift through all of the data that you've produced, and eventually, a lot of times years later, you will finally get to trial, or you'll use a lot of this in depositions, things like that. So how does this work in a more detailed way? A company needs to start preserving data and taking steps to make sure that stuff isn't deleted as soon as they anticipate litigation. When does that trigger exactly? Certainly if you called your attorney, you can reasonably anticipate litigation. If you get a threatening letter or a demand letter, that needs to happen then. Or, of course, if you get served with a complaint, then you'll need to start preserving data. Of course, does that happen? Not in all cases. A lot of the times you'll have some lag, which can lead to data loss, which can cause some serious problems for the client down the road. After the litigation is anticipated, in-house counsel will usually issue a litigation hold, saying to a certain number of employees or the entire firm, saying, hey, you need to start saving this stuff. A lot of these holds are very broad. I'll talk a little bit about some of the problems that can happen with that. And then the data is then collected. This is where the wheels start to fall off as far as an organization's information. The data is then usually sent to a vendor, and that vendor can be a very large outfit that will host everything, or it can be an individual law firm. They've got to then process all of the information. There's a lot of file conversion that has to happen. The preferred file format for all of these documents electronically, believe it or not, is not their native form. It's 8.5 by 11 TIFF images. Why TIFF? Because it's very flat. You can't really mess around with it. But you run into a lot of problems with things that were never meant to be on paper in the first place, like databases, Excel spreadsheets. You add that to the idea of needing to go back and redact some trade secrets or financial information out of daily sales reports that can be thousands and thousands of pages long. It's a very, very time-consuming process. So you take a look at the document. You say, is this responsive to this litigation? Yes or no. is this potentially privileged? A lot of the times you'll have multiple levels of reviewers. So they'll say, yeah, it looks like it might be privileged, so that goes into a separate bucket and somebody else is going to look at it later on. A lot of the times you'll have some problem files because the processing is not really all that effective. So you'll have people going through individually looking at native files. Then the redaction process happens. And what redaction is you sit there and you draw black boxes on the screen over and over and over. And like I said, a lot of the times you'll have spreadsheets that cascade over thousands and thousands of pages. When I was doing this, I actually sat down and I was going to play some video games, and I started to play Command and Conquer, and I got about 2 minutes in and realized that I actually physically couldn't do it because I was so sick of drawing boxes on a screen. I just wanted to kill myself. After all the information is redacted, everything needs to be re-OCR'd and reprocessed again so that the extracted text doesn't have all of the underlying information which then you want to hide. I'm sorry. I can see it, but you can't. Then a lot of the times you'll have another overlay applied to it, and then finally, at that point, you have a production set. Well, how much money are we talking about here, right, for this review process? You're not, depending on the case and how big it is, you could have anything from new people out of law school like myself, contract attorneys going through things, all the way up to associates at big firms and sometimes even partners at big firms going through reading your email and spending a lot of money. I mean, it's a full hourly rate for your attorneys. I remember how much I was making, and just a rough estimate. I have no idea what it actually billed to the client at, but you can imagine very easily around $75 an hour for a contract attorney. And in a lot of these situations, you have floors and floors of attorneys billing $75 an hour doing nothing but going through and reading documents. So the cost just starts adding up so fast at this point. And that's after you've already spent a ballpark estimate of around $1,500 per gigabyte just to process the data to get to the point where the attorneys can start looking at it. So, here's another one. A lot of times you'll have to deal with backup tapes. Think about the cost of restoring backup tapes and putting them in a format that can then be reviewed. It just snowballs very, very quickly. A lot of the costs, though, are caused by users and in just how people interact with computers, because a lot of general users were never taught how to do things efficiently and how to never do things properly. So one of the things that an organization can do to reduce their potential cost is teach people how to use their email. No reply, if you're going to be quoting the entire message below, if it's less than 5 words, do you really need to send it? Here, take a look at this spreadsheet. Do you really need to send a reply saying thanks? Because what happens then is it's not a duplicate message that can be removed. An attorney is going to sit there and read that email now twice. So sometimes you'll see these long email strings, a lot of the times that take place on BlackBerries, where you have just conversation after conversation, 20 pages long, where initially you're starting out talking about a product or something that you're being sued over, and by the end you're talking about football. But either way, if you're talking about trade secrets or other products all intermingled with each other, an attorney has to sit there and draw that box over and over and over and over. How'd you like to spend an entire day reading the same email thread over and over and drawing about 200 boxes over it? It's nonsense. Trying to send links to things instead of just sending the file. You're going to be creating duplicates of the file, sending it all around. In some instances, I've heard of places who sent out daily sales reports for the entire company to all of their middle management sales staff. It's all cumulative, and it's all responsive to the document. So the day after you get it, it's completely irrelevant, but it's still sitting there on your machine. And because it's responsive, and because you're going to need to redact it, people are going to be going through it over and over and over and over. Just change the way BlackBerries work. Corporate executives love to tap away on it, and every single time you quote the entire message below. It doesn't make any sense to have to sit there every time and delete everything if you want to reduce the overall volume of information. Things like that. Here's a good one. A lot of the times, in order to identify ways in which a document can be privileged or not, they'll do a full text search for an attorney's name throughout all the documents, so it'll be pre-flagged. You can imagine that in a very large corporation, if you have an attorney named, Johnson, every one of these documents is going to come up as potentially privileged. And so you're going to have 2 lawyers looking at that. So here's a very simple idea. If you have in-house counsel who's going to be talking about privileged information as well as non-privileged stuff, why not make him use 2 different email addresses? Make him use one for all of his privileged communication. Make him use one for all the other nonsense. That could cut quite a bit of cost out of things. So outside of user education, what really can be done to reduce some of this cost? Single instance email is big. That's a very an emerging trend among companies to go to. Send links, not actual documents. Use a document management system. Users will hate it. I hate my document management system. They all suck. They're just terrible to work with, but in the long run, that's the best way that you can take care of a lot of these problems. And for the CISSPs out there, treat litigation just like any other issue in business continuity. Have a plan and be able to implement it at a moment's notice whenever you hear from the lawyer that it's time to start preserving information. Teach your users to delete things. There's no need to have, your top executive, of course, who's definitely in charge. Everybody else may have a 1 gig limit on their inbox, but when he calls up and says, I don't want to clear out my inbox, increase my size to 10 gigs, well, of course, they're going to say yes, but is that really what needs to happen? Another thing that you can do to reduce risk of some serious stuff down the road is IT people and technology people like having backups, multiple backups, and we don't want to lose the data. So a lot of the times you'll have rogue backups. You got a DVD burned sitting in your desk that nobody knows about that you're ready in case something happens. But down the road, if a lot of that information has already been purged the right way, and then somebody finds out, oh wait, you've got that, thanks. Now your company could be facing a lot of potential sanctions and maybe some very bad, nasty jury instructions when you get to trial. Now I want to talk about another buzzword. That's data map. A lot of lawyers will now say, well, we need to get a data map going. Where's the data map? What data mapping is just an enumeration of where all the stuff is. It can come in a lot of different forms. In fact, this is kind of what I do. And every data map that's done looks a little bit different depending on the organization. But think instead of not what it is, but what you want to do with it and where you would want to use it. So if you're facing a hearing about potential spoliation of evidence and accusations of improper preservation, you want to have, essentially a binder sitting there of all the information, how, where it was originally, what the policies were, what steps we took, logs, narratives, all kinds of stuff. It'll get very large, but it's a very effective way of protecting the company if you're already in litigation. But the beautiful thing is you can do it before litigation. That way, if you get served, your attorney just pulls it right off the shelf. And instead of spending a lot of time wondering where everything is, they can go right to identifying individual custodians and preparing for some of the early pretrial conferences. And of course, you can't secure information unless you know where it is. So this is information that could be very handy to the organization in general. So if you're looking to try and sell some of these changes to infrastructure, like single instance email, like coming up with a data map of some kind, pitch it in all different ways. It improves security, we can reduce cost of storage, and it reduces litigation risk. You can get inside and outside counsel to get on board and agree. they'll twist some arms and they'll get a lot of these changes done that'll make everybody's jobs a lot easier in the long run. But hey, this is a security conference. We're not talking to all business continuity experts here. We want to hear very frightening things. Well, we've got some frightening things for you. Where is all this data going? When I say production, where is it going to go? Well, we already talked about sending all of the data to your vendor or your law firm's vendor. Okay, so it's going to go there. After that, it's going to go to your law firm. Then it's going to go to their law firm. Then it's going to go to their vendor. So all of the data that a lot of the security professionals are paid a lot of money to sit around and protect is going straight out the door to organizations that we don't trust, we don't know anything about, may be completely insecure. It hasn't happened yet, but I think it's something that is somewhat of a forebear was the outfit that was working for the RIAA. They were catching users that were sharing files, and one of their corporate policies was to back up all their email onto Gmail. Well, somebody used some tool and got a hold of all that stuff, and the entire company's email showed up on BitTorrent. So while that didn't happen in a litigation context, we don't want that happening with an entire company's whole data set. And let's not forget what data is. I mean, there's a tendency always to think about this in terms of gigs of data and just data in a very abstract way. We're talking about people's personal email. We're talking about instant messaging logs. Things that go on email. Fights with spouses. Your HR file in many possibilities. Personal financial data. Of course, there's a whole lot of porn on a lot of people's stuff. On top of that, then you have all the stuff that the business really cares about, like trade secrets, financial data, all of your customer data. So all of your data for anybody that you may have interacted with could be going out to a lot of non-trusted places. A lot of financial forecasts, engineering drawings, patent proposals. We're dealing with it's the whole enchilada, if you will. All going out the door, all to a lot of non-trusted organizations. Well, let's dig down a little bit. Let's talk about law firm security. Like we talked about earlier, it's just in 2006 that attorneys started figuring out that computers are interesting, right? Can you imagine the way that how they approach information security at this point? Probably not that great. I know my firm takes it very seriously. We've got a decent team dedicated to that. A lot of firms won't, and that's the corporate defense side of things. Let's talk about the plaintiff's attorneys, the ones that are eventually going to be getting all of your data. These are a lot of times one-man operations, five-man operations. They may not have the money to invest into a lot of security infrastructure. They may not understand. I worked for a plaintiff's attorney once when I started this summer when I was in law school. This is 2004, 2005, something like that. I walk in, and all the client files were sitting on one machine at a secretary's desk that happened to be running Windows Millennium Edition. While she was showing me how to use the computer, it blue screens, of course, and I say, does this happen a lot? Oh, yeah, all the time, at least 3 or 4 times a day. I said, well, where's the backup? Backup? So, it's extrapolate that out to a lot of other attorneys, and that's kind of what you're dealing with. And that's where your data is going. All right. So what about the attitude towards security in general within the leaders of e-discovery? I was up at a certification course, and one of the attendees getting a certification in e-discovery asked the presenter a very, very valid question. He said, I work for this organization. They're very concerned about sending our data across state lines to other places. And the response from the trainer in the certification course was, well, just tell them that the odds of this vendor getting hacked are about the same as the law firm, and they just don't need to worry about that at all. I was shocked. I mean, I'd been very quiet the entire time, but I couldn't raise my hand up fast enough to introduce the idea of, I don't know, maybe have a third-party penetration test done before you send your stuff to a vendor. The woman said, wow, that's a really good idea. Nobody's really ever brought that up before. And this is a person giving certifications in this stuff, right? So what about these vendors, right? Now, I'll leave you all to make the conclusions about the potential vulnerabilities in a lot of these underlying technologies. But let's talk about them a little bit. Everybody and their brother right now is coming out with a lot of tools to review data. I mean, this is a hot area. It's a great way to make a buck. I mean, all you're doing is you're making a front end for a database. So what do law firms and attorneys love? Man, just like everybody else, they love web-based applications. If you guys saw the presentation yesterday, web applications are just, in general, broken. A lot of these applications, the vendors of these tools they'll give you an option. They'll either host the data for you, which is overall a very positive thing if you don't have the capacity there, or they'll actually sell it to you so that you can install it on your own stuff. So just like with any major software application, you're going to have a slight lag between patches at law firms. So you may have some insecure stuff still hanging out there. But what about some of these vendors themselves? Okay, the technologies themselves. A lot of them are built on SQL or Oracle databases, which, of course, are really easy to secure. A lot of firms are tied very tightly with our friends at Microsoft. So they're part of the very big, easy target. A lot of the tools will add some Flash to it. Let's add some stuff like some Java components. Let's have some ActiveX controls in there. Let's make sure that we require things like Internet Explorer 6 to use this, and let that kind of hang out there. When these vendors talk about security, because when they're dealing with law firms, they love to talk about it, and they say, we have the same level of security that banks have, SSL. And I talk to these people, and I'm like, okay, great. What else can you tell me? Well, it's the same level of security that banks have. Okay, so let's keep this going a little bit. I was last August when I got back from DEF CON, we had a Jeans Day at work, so I took full advantage of that and wore one of the Hacksaw shirts, bright red, yes, very kind of out there in your face, and we had some people from the vendor up to talk to us about some of the problems that we've been having with the database and things like that. And specifically, we were having some problems with some specific formats not refreshing enough, and I'm thinking to myself, well, we can kind of change the way that Apache approaches individual file formats. So I bring this up with the developers, and I said, well, can't you just, change this in the configuration? The guy said, well, what web server is that? I was like, Apache? Never heard of it. Okay, let's push this a little bit further. What web server are you guys using? We roll our own. I was so shocked. I had no response because I couldn't understand why in the world you would even want to do that. Security through obscurity is one thing, but if you're having problems with uptime, I don't think that you're achieving much on that goal. That was kind of my response. One of the very nice things about being one of the newest members of my team is that I'm now kind of the go-to guy for all the vendors to talk to. I'm busy, talk to the new guy. So I love asking them about security, and they just give up the goods. It's fantastic. I was talking to one outfit, and I said, well, do you guys do pen tests on the software before we buy it or for your own hosted stuff? The response was, well, we've heard from some clients that have had some penetration tests done that we had some vulnerabilities, but we fixed those after they told us about them, and we don't really do any of that ourselves. So you guys are going to want to kind of test your software. And I said, so you guys expect me to be responsible for the security of your software that you're asking me to pay for? Well, kind of. Okay, that's interesting. So, once again, it's like that. Here's another great one. Same kind of setup. I say, have you brought in somebody to do a pen test? Well, this time it was, what's a pen test? Well, the concept is you pay somebody to come in and try and break your stuff and break into it. That way you can secure it if you did to. Why would we ever have someone come in and try and break our software? Once again, I had very little to say. I'm just, it's like, well, I guess this conversation is over at this point. I know where we're going here. So here's another great one for people that are involved in forensics. You'll especially love this, or have had any kind of involvement with law enforcement. I'm talking to this guy, and he comes to my office, and we're talking about security and me coming out and speaking at these things. He's like, yeah, it's interesting because at our place, people send us hard drives all the time. We're processing lots and lots and lots of data and terabytes of stuff constantly. At no point have we ever received any hard drive that's ever been encrypted. And I was like, well, how do you handle chain of custody? Yeah, but everything just kind of comes and gets dumped in the mailroom. Myself, what? Seriously? You're just telling me this? I'll be right down. So let's put this even more into perspective. Lots of big law firms will host all of this data themselves, but lots of these vendors will host it for you. But think about it. If you're an attacker looking to steal some trade secrets, commit some corporate espionage, why would we come to the individual organization at this point and try and go after your security with your dedicated security staff when maybe we can go and try and attack a vendor? So that way, instead of just getting company A's stuff, who knows? Maybe we'll get B, C, and D too. It's a field day. That's a much bigger target. So in conclusion, what can we do as information technology professionals to deal with some of these new issues, to try and continue to protect our data, try and control costs? Get to know the lawyers at your in-house counsel, and if they're around, some of your out-house counsel. Get to know your lawyers in a friendly way, not just by breaking policy and getting in trouble either. As a company, find your stuff, catalog it, figure out where it is, and plan ahead for litigation. In this day and age, litigation is a certainty at some point in a company's life cycle. You need to make a plan for that. And on the security end of things, you need to demand more from vendors. If you guys know that information is going to be going out, demand to see third-party reports. Demand full disclosure from them. Nobody's asking for this stuff right now, and these companies are certainly not going to give it up. Otherwise, depending on your organization and what the culture is, it might just be time to get right with the man, and that might be the answer. So, at that, I think I've got about 7 minutes or so. Do you guys have any questions for me? Yeah.
John, several years ago, I worked with an organization that had a document retention policy. I was building a security policy for them. And their document retention policy was 90 days. On day 91, it was destroyed by default. And this is a multi-billion-dollar large organization. Probably the tobacco companies wish they had something like that. In view of that type of a program where you, by exception, extend things past 90, does that provide A, significant defense against discovery, people pulling stuff out in the background, and B, at that point, because it's institutionalized in policy that's been long-standing, nobody can come back and say, well, you destroyed these documents to get out of discovery. Now we've been doing them for years. So is that something you'd recommend?
That's a great question. The question involves document retention and document destruction policies. And the example was a 90-day automatic deletion policy and how effective that is as a defense against accusations of spoliation of evidence down the road. Absolutely. A document retention policy should be very high on the list of things to do to adapt to the discovery rules. Now, what should your policy be? Here comes the lawyer answers again. It depends. If you're a publicly traded company, or if you're in the stock exchange, things like this, you already have that dictated. 7 years. 90 days is pretty short. There was a case where an outfit just said, at the end of the week we delete everything, as far as email goes. The court said that's pretty unreasonable. Essentially that's a little bit too short. In those instances, work with your attorneys and figure out those policies. But work with them and find organizations that understand electronic discovery and understand the shaping of these policies so that they can find one that's going to work for your individual organization, because they are all different. And just taking a sample policy off the internet is probably not going to do it. Another problem that can come up is, like you said, exceptions to the rule, and especially with who gets those exceptions made for them. Ironically, the guy on the sales rep out in the field is probably not going to be the one targeted as a custodian of documents during a big lawsuit. The CEO, the director of marketing, all the guys that have all of the stuff that people really want, they're the ones that are going to get these exceptions. So the information's still going to be there. So you've got to pound away and make sure that all of these people are actually following the policy. Yeah.
I heard somewhere that legislature is looking into making companies criminally liable for the information not only within their own company, but vendors, partners, and all that stuff. How far is the legislature of that, and what does that mean to us?
I don't know. Is that. I'm not sure. I always believe that more legislation is never the answer for pretty much anything. You kind of let the courts kind of deal with it. That's kind of the nice thing about the rule changes to the rules of civil procedure, is that it will allow a lot of flexibility between the parties to kind of come to agreement. It kind of depends on what kind of level of liability they're talking about, being liable for somebody else's data. To expect one organization to be responsible for the security of an organization, 3 times removed, a subcontractor is kind of that's a little bit much probably, but it's still something that you probably need to take into account just from a practical standpoint.
Well, it depends on the industry. Financial services, retail, things like that, where you're moving money. There's several different points. You have to verify each point of that security if you're sending that data.
Yeah, and the financial services are really, they're further along in this. They've been dealing with it because of SOX and the big major cases. You all notice that I haven't mentioned a single case before just now? Most attorneys pound you with cases. Morgan Stanley, UBS, Warburg, Zuba Lake, they're the ones that got hit real early with a lot of the big sanctions, with the adverse inference, where a lot of this case law really stemmed from. So, and if you guys want to know the wrong way to handle things, read some of these opinions. There's like 5 Zuba Lake opinions. The Morgan Stanley opinion, where there were thousands of backup tapes that were never analyzed, and they found them in a closet. They got into the point where they were doing what's called the 30B6 deposition, where they bring in somebody high up in IT to kind of talk about what their structure is and how it's set up. And the guy said unequivocally, yes, we've gone through and we've found all the backup tapes, we've produced all the information. Well, he goes home and he realizes, wow, that was kind of a ridiculous thing for me to say. I guess I better go check, maybe see if there are any other tapes laying around. The first place he looked, he found a box of backup tapes that hadn't been produced. It only got worse from there. And that was where there was an adverse inference. What the adverse inference is kind of the worst type of sanction for any group going through litigation. And this is kind of the scary part for individuals that might be sued. civilly under federal law, is that if the data is destroyed or it isn't there, and the court finds a number of factors, they'll actually tell the jury, okay, you didn't see any evidence of this because it's not there. The fact that it's not there, you can hold that against the defendant. You can assume that what the plaintiff said is there. That's the death knell to any defendant. It's time to get out the checkbook if that's going to happen. So that's, we haven't seen it start to happen with individuals yet. I think the adverse inference instruction was given with torrent spy, which that's also another frightening case that happened. Just because the court essentially set up a judicial keylogger. What was happening in that case is you had all the people connecting to the BitTorrent tracker, and torrent spy said, well, we don't keep any logs. And the judge couldn't really force them to turn on the logs, really. So what they did was they just required that everything that passed through RAM, that's right, RAM, to be retained. And when I read the opinion, I had to read it like 3 times before I realized, before it really set in, that, yeah, that's a keylogger. Now, that's pretty rare, and that was a very special circumstance. The people at Torrent Spy hadn't exactly been playing nicely with the court or with the other side at all. So we're hoping right now, at least I'm hoping, that that's a very far outlier. But you never know when a plaintiff's attorney is going to read that opinion. They're going to go to the judge. They're going to have a defense attorney that isn't really all that savvy, and he's, all of a sudden you're going to find out that you need to preserve everything that was going through RAM in all of your machines at your office. And the sad thing is they won't consult with IT a lot of the times before these orders are given. I've heard of sometimes that the transmission of data to the vendor from the client started without even notifying information security. So, you've gigs and gigs and gigs of data just streaming out to an unknown IP address. Might want to tell somebody that this is going to happen. So, what other questions do you guys have? Yeah.
Since this message logging in general is based on user preferences, you have sporadic cases where you do have these logged, but you don't have those logged. Do you recommend going to a centralized server where everything is logged, or tell everybody to go log, or tell everybody to log, or what are your thoughts on that?
That's an interesting case, and I get asked. That's kind of an emerging thing because now lawyers are figuring out that instant message logs exist. It's very similar to that. It's all in what policy works for you guys. If you have a policy at the organization that employees are not to use SMS for business purposes, and you can show that you don't do that, then there may not be a reason to keep around the logs. But if you are relying on that, then it needs to be rolled into your document retention policy just like everything else. Yeah.
Speaking from the IT side, if you are given, if your company is given an order which effectively is a physical impossibility, what are the real alternatives? Like, what can you do in this situation?
The question is, which probably will happen at some point to everybody in this room, you'll get a litigation hold that is obscenely broad and possibly even just physically impossible to comply with. Retain all backup tapes from now until perpetuity, something like that. If you get it, you need to get a hold of the in-house counsel and say, I need to talk to you. We need to get together with outside counsel. We need to work through this preservation, through this hold, because sometimes you get a preservation order from the court, which is more difficult to change. If it's just a hold that's been sent, you can tell it's kind of a boilerplate form from in-house counsel. Talk to them, find out what the case is about, figure out the best way to do it, and work with them. Attorneys in IT don't really talk very much. We're two opposing worlds. I don't think we're all that different when you get down to it, but they just don't talk, and a lot of times in-house counsel just doesn't understand technology. So you need to help them through it. Educate the attorneys. Help them understand the technology And then hopefully as you go through things, they'll help you understand the law and why you're being required to do it in the first place. All right, well, I thank you all for coming. If you guys have any more questions, I'll be around all day. So thank you again.